I'm an ardent believer of the benefits of technology. Just yesterday, we saw the adverse effects of technological dependence because of the Microsoft outage. I was so used to arguing my cases and forgetting about the cases after judgment was reserved or the order was passed. I gradually got used to, but the lawyers are always one step ahead of the judges. And they said to me, Chief Justice, if you have to apologize, then you have to apologize twice, because you have to apologize for Justice Sundaresh's appointment because you have stolen him from us. Yesterday day before yesterday, when we concluded the swearing-in ceremony of Brother Justice Mahadevan as a judge of the Supreme Court, we had a large contingent of lawyers who had come from Tamil Nadu. So I walked up to them over the coffee in the lounge, in the judge's lounge, and I apologized to them. So they were a little taken aback, because on a happy occasion like this, when you are celebrating the appointment of a judge of the Supreme Court, why is the Chief Justice of India apologizing to us? So I said, I apologize to you for having stolen one of your finest judges to the Supreme Court. But the lawyers are always one step ahead of the judges. And they said to me, Chief Justice, if you have to apologize, then you have to apologize twice, because you have to apologize for Justice Sundaresh's appointment because you have stolen him from us. But then I thought, they had forgotten one more, and that was my dear colleague, Brother Vishwanathan, Vishy to all of us, because we stole him. But there is a sting in the tail, and which is that the bar of limitation applies after 1 year on the bench. In this case, of course, Brother Mahadevan was appointed and sworn in on the 18th of July 2024, Justice Vishwanathan on the 19th of May 2023, and Brother Sundaresh on 31st of August 2021. So in a sense, our apologies for having stolen two fine judges, one from the bar and one from the bench, is time barred insofar as Justice Vishwanathan and Justice Sundaresh are concerned. As everybody knows, I'm an ardent believer of the benefits of technology. Just yesterday, we saw the adverse effects of technological dependence because of the Microsoft outage, and flights all over the country were cancelled. Numerous flights from Delhi were cancelled. But I think it is the love that the people of Madurai showered upon me during my last trip that has ensured my presence amongst all of you today. As I recall my trip to Madurai last year, I am reminded of the first 3 verses of the Atichudi, written by the great Tamil poetess Avaiyar. And she says, pardon a little bit of my Marathi accent in Tamil when I speak in Tamil. And she says, Aram Seya Virumbi, Aruvadu Sinam, Eyalavadu Karavel, have the desire to do good deeds. Anger should be reduced or controlled, and help to your best possible extent. What this famous Tamil poetess said is so symbolizing the quest for justice. The first thought that she expressed brings a sense of justice, have the desire to do good deeds. The second, when she tells us to control our anger, brings about a sense of emotional equanimity, which is so important to the dispensation of justice. And the third, help to your best possible extent, highlights the need for empathy and for compassion, without which our profession cannot exist. I'm thankful to all the wonderful people I got the opportunity to interact with during my last trip here. They truly lived up to the verses and introduced me to the goodness of Tamil culture. Madurai is called Tunga Nagaram, or the city that never sleeps, because its markets are always available to cater to the throngs of people visiting it every single day. The city truly has a lot to offer to everyone, from a temple town for devotees to find solace in, to a city that never sleeps for people with an active nightlife. This reflects the inviting and hospitable culture of this great city. It is therefore no surprise that Madurai was selected to be the venue for the permanent bench of the Madras High Court. And in that sense, Madurai is an eternal symbol that justice itself never sleeps, and we demonstrated it during COVID. The tale of the Madras High Court is like that of a banyan tree. The older the banyan tree gets, the more its branches develop prop roots, and each of these prop roots is an entry into a fascinating chapter of history and legal development. A beautiful book was presented to me last evening containing the translations in English of the Naladiyar. And while reading it last night, I found this beautiful allegory from Tirukural, written in the 9th century by Jain monks. And he says that, couplet says, the quatrain states, a tiny banyan seed grows all around, provides shadow massively, and as such, even though small a gift if given to great men, would grow widespread, even wider than the sky. Article 214 of the Constitution stipulates that there shall be a high court for each state. However, one would be highly mistaken if they believed that the impact of the judgments coming out of the Madras High Court, and in particular the Madurai bench, is restricted to the state of Tamil Nadu. Lawyers, judges, and citizens across the country look at the judgments emanating out of the Madurai bench of the Madras High Court with great appreciation. It is remarkable that the bar, as well as the judges of the High Court bench, have been able to establish such a reputation in a short span of only 20 years. When I became a judge of the High Court, it was a completely different universe. I was so used to arguing my cases and forgetting about the cases after judgment was reserved or the order was passed. I gradually got used to being a judge of the High Court. When I became Chief Justice of the Allahabad High Court, it was a completely different universe, where you had to look after the affairs of the judiciary in the largest state in the country. When I came to the Supreme Court, it became a completely new experience. The rhythm, the music of the work of the Supreme Court is so distinct that even an experienced judge, I was 16 years into judgeship when I went to the Supreme Court, even a judge with 16 years of experience in the High Courts finds it difficult to understand and truly fathom the nature of the work of the Supreme Court, because you deal with problems from across the nation. The reason I thought I should mention this is that when the Madurai bench was established, it was essentially a district bar. And the challenges before the district bar were numerous, because from being lawyers practicing before the district court, your orientation had to shift from the problems of the district to the problems of the state, to the culture and identity of Tamil Nadu, as opposed to the identity or culture of Madurai itself. Setting up a bench of the High Court is not just about setting up buildings or setting up infrastructure or creating courtrooms or furnishing those courtrooms, though they are essential appendages to judicial work. The crucial part is about setting up conventions, about setting up traditions, which will endure for the future. And I dare say that in the last 20 years, the Madurai bench has made that transition into truly being a representative of the great traditions of the Madras High Court. Since I have taken over as the Chief Justice of India, I have focused on the issue of accessibility of courts and making them citizen-centric. One of the facets of accessibility is overcoming language and distance barriers between the citizens and the courts. Key initiatives have been taken to address both these facets, like the translation of cases in regional languages and developing the infrastructure of e-courts and virtual hearings. Benches of the High Court, like the Madurai bench, seeded this very idea of bringing justice as close to the doorsteps of the citizens as possible. What better way for us as judges of the Supreme Court to reach out to every corner of the state of Tamil Nadu than by insisting that our judgment should be translated into Tamil. Nearly 2,000 judgments of the Supreme Court are translated into Tamil. And I do believe that this translation is not merely for us to reach out to citizens who are residing in this state in respect of cases decided by us pertaining to the state of Tamil Nadu, but that our work across the nation should be brought home in every regional language which is recognized by the Constitution. And I do hope that access to the judgments of the Supreme Court in Tamil will enable us as judges of the Supreme Court to reach out to lawyers across the state, to enable us to reach out to citizens across the state, to remind them that we exist for you and you primarily. It is said that we hold this earth not as an inheritance from our ancestors, but in debt for our future generations. I've always believed that when it comes to the role of courts, it is not only the hope of the butcher, the baker, and the candlestick maker, but is also a repository of history for our future generations to adjudge us. Our time on earth may be borrowed, but our deeds are immortal. I call our courts a repository of history because the cases that come before a court reflect the social milieu and the contemporary issues that face society. So the next time a lawyer from Delhi engages in a friendly competition about the development of the bar in Delhi and the Madras High Court, you can say that even Delhi looks at Madurai when it gets into trouble. While looking at our growth and reflecting on our achievements, I would like to re-agitate an issue facing our legal fraternity. This is the remuneration which is paid to lawyers at the entry level by their seniors. At a personal level, I believe that senior members of the bar must promote talent and help junior lawyers by giving them a dignified amount to sustain themselves as well. But at a systemic level, I believe that the low amounts ranging from rupees 5,000 onwards per month lead to gatekeeping of our profession. The usual defense by recruiting chambers or lawyers for such low pay is that the first few years of a young associate's character or career